Hello, I am Michael Molinaro. I am a California attorney and I've worked as a teacher and I've volunteered as a soccer coach. I'm very concerned with the state of California law that is affected by Alex Baker's appeal, and I'm concerned from the perspectives of learning and teaching. In California, we have a definition of abuse under the Domestic Violence Prevention Act that I believe totally interferes with learning and teaching freedom in America, particularly freedom of speech. And Alex's case, where he has appealed to the California Supreme Court and his next proceeding to the United States Supreme Court, involves understanding our freedoms, including our freedom of speech, freedoms to talk to family, freedom to file papers in court and bring motions in court that say words. Now, as a teacher, going back to, let's say, Mother Goose age teaching, you learn things like sticks and stones can break my bones, but words will never hurt me. And there's a big distinction between preventing domestic violence or responding to domestic violence that has occurred to try and put restraining orders in place, orders that say make people stay away from each other or forfeit their right to own firearms. To teach that, and it is a laudable goal, nonetheless conflicts with teaching what we are free to say in our country. People who go to school at all stages, from grade school where you learn to pledge allegiance to your flag and learn about freedom of speech and how freedom makes America great, study it, and then if you get to university or graduate school like law school, or to professional studies like continuing education for people who are already lawyers, you learn what is protected speech and what is not protected speech. So in theory, you learn nationwide that true threats of imminent bodily harm, of imminent serious violence, are not protected speech, that shouting fire in a crowded theater is not protected speech, that obscenity is not protected speech, but that many things are protected speech, including even possibly angry or hateful words, if they are not imminently threatening some real harm. You might learn that exclamations like "you rotten person," but translated to me more serious, are protected speech. In California, the definition of abuse in the Domestic Violence Prevention Act, I believe, has gone too far and is unconstitutional, because if someone says something that upsets a family member of theirs in California or upsets someone they dated romantically in California, a restraining order can be imposed. And that restraining order puts the verbal abuser who said something that upset another person or wrote something that upset another person, it puts them on a list under the CLETS system, the California Law Enforcement Technologies system of reporting who abusers are. A list that all employers can see throughout the nation, puts them on another list in gun stores where they cannot buy firearms and must surrender their firearms. Someone could say something in Michigan, type it on Facebook or Instagram, and have California family or dates complain. They would lose their right to bear arms nationwide, and legally it's on a mere preponderance of the evidence. Not very clear evidence is required. The very least evidence is required of the person complaining so that they get their protection. And the problem is, this means people are losing constitutional rights, such as rights to confront witnesses against them. If the witness is a upset, sensitive family member, the court might protect the witness. They're losing the right to bear arms. They're losing rights to due process. And it's all due to a definition of abuse in California that we call engaging in conduct that has been or could be enjoined. Alex's writ for certiorari to the Supreme Court, that I hope you will support, seeks to call that unconstitutional. And there's a case interpreting it called Marriage of Nant Carney that calls things that could be enjoined destroying the mental or emotional calm of the other party to the restraining order case. I believe that should be overturned. Anyone who's followed the U.S. Supreme Court knows there is a new justice on it, Neil Gorsuch. He wrote a very detailed opinion about law in the case Sessions versus DiMaia, talking about separation of powers, how legislatures should make laws, courts should not create laws. Well, the courts have created a law that creates a California exception to our freedoms of speech. It creates a California exception where if you say something or write something that destroys the mental or emotional calm of someone you dated or someone who is your family member, you lose your rights, like your rights to be off this abuser list, your rights to be off the no guns possibly owned list, your rights to clear and convincing evidence that exist under many other cases. So please support Alex's petition. I support it wholeheartedly and have contributed a lot of writing to it, trying to bring my experience as an attorney since 1989 to bear on it. My experience as a constitutional law student in college, my experience as a LA Unified substitute teacher and soccer coach with the AYSO. We need simple ideas to grasp about freedom of speech and freedom even to write things and submit them to court. Alex's case is unique because writings he submitted to court arguing the law were found to be abusive, to upset his family members' state of mind, and to therefore restrain him. That gives him standing, a place of harm from which he can challenge the statute that is fairly unique in my experience. I don't know of many other people who had restraining orders entered against them for reasons like that. So Alex's case is a great platform from which to mount this attack against an unconstitutional law that is void for vagueness. Please join him to support him. Thank you.